judge claims otherwise, they are violating the very principles they swore to uphold. What to do when a judge claims the Constitution doesn't apply in this courtroom? When a judge makes a statement like, the Constitution doesn't apply in this courtroom, they are essentially challenging your assertion of constitutional rights. This is a red flag, and while it may seem shocking, it's not uncommon for judges to attempt to sidestep constitutional arguments, particularly in statutory courts. The key here is to remain calm, composed, and strategic. Below is a guide on how to handle such a situation. 1. Understand what they're doing. When a judge says the Constitution doesn't apply, they're typically attempting to assert statutory jurisdiction. The judge may be implying that this is a statutory court, operating under statutory law, and that constitutional arguments are irrelevant to statutory enforcement. Intimidating or testing your resolve. They may be trying to throw you off your game and see if you'll back down or become flustered. Maintaining control. Judges often dislike constitutional arguments because they force the court to acknowledge limits to its authority. This statement is not a lawful ruling, it's a tactic. The Constitution is the supreme law of the land and applies to all courts in the United States. 2. What to say in response. If the judge claims the Constitution doesn't apply, don't react emotionally. Instead, calmly assert your position and force them to clarify or justify their claim. Here's how to respond. A. Ask for clarification. Your Honor, are you stating for the record that the Constitution does not apply in this courtroom? I would like that noted on the record. This forces the judge to either double down, which they likely won't want to do, or backtrack. B. Reassert the Constitution's authority. Your Honor, the Constitution is the supreme law of the land under Marbury v. Madison, 1803, and all statutes, codes, and court proceedings are subordinate to it. I respectfully ask how this court operates if not under the authority of the Constitution. C. Challenge jurisdiction. If the Constitution does not apply, under what authority is this court operating? I request that the court establish jurisdiction on the record, including the specific constitutional or statutory authority it relies upon. D. Object to the judge's statement. Your Honor, I object to the assertion that the Constitution does not apply in this courtroom. Without constitutional protections, due process cannot exist, and these proceedings would be unlawful. Third, shift the burden to the judge. The judge has made a bold statement. Now it's time to make them explain it. Shift the burden back to them to prove their authority. A. Demand proof of jurisdiction. Your Honor, I request that you provide evidence of the court's jurisdiction and explain how this court is not bound by the Constitution. Without jurisdiction or constitutional protections, this proceeding is invalid. B. Force them to address due process. Your Honor, the 5th and 14th Amendments guarantee my right to due process. If the Constitution does not apply, how is my right to due process being upheld in this court? C. Request judicial notice. I respectfully request that the court take judicial notice that the Constitution is the supreme law of the land and applies to all courts within the United States. Without the Constitution, this court cannot lawfully proceed. 4. If they double down. If the judge continues to insist the Constitution doesn't apply, you can escalate your response. A. Preserve the record for appeal. Your Honor, let the record reflect that this court has stated the Constitution does not apply here. I object and reserve the issue for appeal. This ensures that their statement is documented, giving you grounds to challenge the ruling later. B. File a motion for judicial recusal. Argue that the judge has shown bias or an unwillingness to uphold constitutional rights. Example. Your Honor, I move for your recusal on the grounds that you've indicated this court is not bound by the Constitution, which compromises my right to a fair and impartial hearing. C. Invoke the oath of office. All judges swear an oath to uphold the Constitution. If the judge claims it doesn't apply, they're violating that oath. Say, Your Honor, you have sworn an oath to uphold the Constitution. Are you now disavowing that oath? I request clarification on the record. 5. What the law says. The Constitution applies to all courts in the United States. Here's why. A. Constitution as supreme law. Marbury v. Madison, 1803. All laws which are repugnant to the Constitution are null and void. The Supremacy Clause, Article 6, Clause 2, states that the Constitution and laws made under its authority are the highest laws of the land. No court can lawfully operate outside its bounds. B. Due process protections. The 5th and 14th Amendments guarantee due process, which applies in all courts, whether federal, state, or municipal. If the judge claims the Constitution doesn't apply, they are denying you due process. Constitution. Oath of office. Judges are bound by their oath to uphold the Constitution. If they claim the Constitution doesn't apply, they're acting outside their lawful authority. 6. Stay composed and strategic. While it can be infuriating to hear a judge claim the Constitution doesn't apply, It's critical to remain calm and composed. These situations are often tests to see if you'll lose your cool or back down. Remember, be respectful. Don't insult or accuse the judge. Stick to legal arguments and facts. Stay focused. Keep bringing the conversation back to jurisdiction, due process, and the supremacy of the Constitution. Document everything. Ensure the court record reflects the judge's statements and your objections. This is crucial for appeals. 7. Real-world example. Judge, the Constitution doesn't apply in this courtroom. Your Honor, I respectfully ask for clarification. Are you stating for the record that this court does not operate under the authority of the Constitution? Please let the record reflect this statement. The Constitution is the supreme law of the land under Marbury v. Madison. Without it, this court has no lawful authority to proceed. I request that the court establish jurisdiction on the record. Your Honor, I object to this statement and reserve this issue for appeal. I request judicial notice that the Constitution guarantees my right to due process and applies to these proceedings. 8. Final thoughts. When a judge claims the Constitution doesn't apply, it's either a scare tactic, a misunderstanding, or a blatant abuse of authority. Regardless of their motivation, your job is to remain calm, challenge their statement respectfully, and force them to either clarify or correct themselves. Always document their words for the record and preserve your objections for appeal. Remember, the Constitution is not a suggestion. It's the foundation of all law. If a judge claims otherwise, they are violating the very principles they swore to uphold. What